The Coase lecture provides us with a really wonderful opportunity both to remember Ronald, talk about what Ronald's legacy is, and also honor one of our own faculty members who follows in Ronald's great footsteps and who does wonderful work in the area typically of law and economics. Now, it's impossible to overstate the influence of Ronald Coase's thinking on American law. And everyone who passes through the doors of this law school understands what has come to be known as the Coase theorem. And Douglas always reminds me that it's Coase theorem, right, rather than Coase theorem. Well, Ronald never thought of it as a theorem. It is essentially the idea that under perfect competition and zero externalities, private and social costs are essentially the same. Put in the more familiar way, the Coase theorem states that in the absence of transactions costs, we should observe resources flowing to their highest valued uses regardless of their initial allocation. Now, the famous story of the Coase theorem was that Ronald, when he originally presented this idea to the law school, to the law and economics workshop, it was roundly rejected by almost all of the attendees at the workshop. Then after dinner and drinks and reflection and disagreement, most particularly by Milton Friedman, all 22 members of the law and economics workshop decided at the end of that dinner that Ronald was correct in his conclusions. My guess is that probably wouldn't have occurred today. I don't think any group of 22 faculty members at the University of Chicago would agree to almost anything, but nonetheless, it did then. So over the course of his career, Ronald challenged the increasingly mathematical, increasingly detached field of economics, and challenged economists and law and economists to live and operate in the real world. What has become known as the Coasean world, where transactions costs are free, and competition is perfect, was really, in Ronald's words, quote, the world of modern economic theory, and one which I was hoping to persuade them to leave, end quote. Ronald recognized that the world is filled with messy transactions, with choices constrained not just by budgets, but also by the design of the very institutions that we choose. Ronald invited us to live and to work and to make choices in the world as it is rather than as we wish it were. And that's one of the reasons why his thinking is so powerful today. And it's also one of the reasons why people who come to the University of Chicago get such a great education and go on to be so influential, because not only does one learn the theory, which is incredibly important, but also understand the limits of the theory and the way theory applies in the real world. And while Ronald did not invent law and economics, his ideas became the foundation for much of its development. Now, a recent volume of The Record, which is our alumni magazine, reminded me how true and how impactful Ronald's work was. You read the remembrances, and it's just a tremendous variety of people writing in different fields, including, for example, Douglas Baird, Saul Levmore, Jeff Stone, and Mary Ann Case. Not people who necessarily share the same worldview, not necessarily people who share the same scholarly background, but each of them recognizing the contributions that Ronald Coase made to their own thinking and careers. And it's particularly fitting this year that the Coase lecturer is Richard McAdams. Richard is the Bernard D. Meltzer Professor of Law and Aaron Director Research Scholar at the law school. Richard holds a BA in Economics from the University of North Carolina, a JD from the University of Virginia, went on to clerk for Judge Harrison Winter of the Fourth Circuit, and then practiced law at Morgan, Lewis, and Bockius. In many ways, he's the ideal lawyer-economist, which, as Dick Posner once suggested, means he's trained in the law, trained in economics, but has an insider's understanding of the law that comes from practical legal experience. Now, Richard's research in criminal law has been focused on what has been termed the law's expressive powers. Its power to coordinate behavior, to teach its adherents about possible risks, to change or update individuals' attitudes, and to cause individuals to change their future behavior based upon these updated beliefs. Richard's fundamental question is, why do people obey the law? And while traditional economists would say that people obey the law because legislators make disobedience very costly, Richard's research provides a much more interesting answer to that question. The law, the courts, and legal enforcers influence our behavior even when they are not able to impose costs on us. So the law's expressive powers, not just its coercive powers, must be important. Now, Richard's work in the area of social norms is among the very best in the field. He has garnered international praise and influence through his research and through his publications. And as some of you know, I asked Richard to do this lecture last year, not this year, and he was unable to do it. And why was he unable to do it? Because he was in the midst, beginning his service, his 2-year service, as co-chair of our faculty appointments committee, a service which I must say has been tremendously successful. Now, this delay has turned out to be quite providential, because we can think of this year's Coase lecture not just as a normal Coase lecture, but actually as an early celebration for Richard, whose book, The Expressive Powers of Law, Theories and Limits, will be published by Harvard University Press this fall. And following Richard's lecture, I would like to invite all of you to join us in the atrium again for a celebration and reception. And with that, let me introduce Richard McAdams.
Thanks, Mike. That was very kind, and indeed it is. I am very honored to be giving a Coase lecture, and it is bittersweet for it to be the first one after Ronald Coase's passing. But I look forward to seeing many more in the future. So yes, Mike introduced my topic very nicely. This is perhaps going to be the cover of the book even. You can go on Amazon maybe and try to sign up to buy it in advance. I don't actually know that it's ready. I do I do ask this fundamental question: how does law influence behavior, which is often characterized as why do people obey law, though in some ways law will sometimes have unintentional effects besides compliance. The standard accounts are, in economics, of course, deterrence, as Mike just said, that you change the cost of behavior through legal sanctions. To a lesser degree, incapacitation, that is, certain sanctions, such as prison, just render it impossible for a person to commit certain crimes, such as bank robbery. Both of these emphasize the importance of sanctions to what the law does to behavior. Even when law talks about default rules, I think, at bottom, the reason default rules matter, even though you don't have to opt into them, or you could circumvent them, is because when you do opt into them, they're enforced with legal sanctions. Now, outside of economics, psychology and sociology give a different answer, and I think of this as the main competitor to economic explanations of legal compliance. It's legitimacy. It's the idea that human beings are socialized to defer to authority they regard as legitimate. Could be science, could be religion, and for many people, it includes law. And the psychologists and sociologists then spend their time trying to identify the characteristics of law that give it this legitimacy power and make people more likely to comply with it. So today's subject, and much of my work for all too long, I guess, has been an alternative account to these two standard accounts. Accounts I call expressive accounts. As you can see, there's not one, there's really two: the expressive powers of law, not power. Law is focal point and law is information. These are based in economics. They are, I use rational choice assumptions and then derive from them some other powers that law has besides its deterrence power. And in doing that, I should say that my work does not critique deterrence. It does not critique legitimacy. I assume that those effects are real, but I also assume that this is an important enough question, how does law affect behavior, that we'd like to know all of the mechanisms by which law affects behavior, not just one or two. All right, so I also should say, if anybody spends time reading legal literature and looking at the literature that talks about expressive law or expressive theories of law, I think of there as being at least four distinct projects. And so my book is not sort of about all of them, because I don't think it coherently you could be about all of them. And I just put the four up here. Two of them are normative. My book is primarily a positive theory of law's effects on behavior, not normative theories. I do at the end examine some normative implications. And there's also there's also an expressive politics theory of law, a kind of political science attempt to explain why the law has the content that it has by looking at the meaning that the law has for powerful political actors. But my positive theory focuses on the explanation of behavior. Let me say something about what motivates this paper, or this project. There's a lot of puzzling compliance, and it's not always with courts, but let me just use this as an example. Both historically and today, there are courts that seem to generate compliance even though they don't seem to wield the power of sanctions. Historically, maybe the most famous of these is the Saga Icelandic courts of medieval Iceland that existed without any executive branch whatsoever. So there was no bailiff, there was no sheriff. If you sued someone, the court had no way to compel them to be present. If you got a judgment from the court, there was no other mechanism besides your own power to enforce the judgment, which raised the question, why did people bother? If it was just a question of whether they were powerful enough to extract money from their adversary, why would they need to go to a court and get a judgment? But apparently the courts were doing something for 3 centuries, even though they lacked the power of sanctions. I didn't mean to say 17th and 18th pirate, but 17th and 18th century pirates. Peter Leeson, an economist, has written a lot about pirates and says that they use quartermasters for dispute resolution between pirates, and the quartermasters, who in some ways had as much power as the captain, was not just ordering people to resolve their disputes. He was offering a way that they could resolve their dispute, like an arbitrator, but they were free to reject it and to go on to the next dispute resolution mechanism, which was a duel. But people frequently went ahead and accepted what the quartermaster said. As contemporary examples, Tom Ginsburg and I have written about the International Court of Justice, which rarely has any way of sanctioning countries that violate its orders, and yet we find I think it was 68% compliance within a year for decisions on the merits. You might also say constitutional judicial review is something of a puzzle, where the court rules against a legislative or executive branch, and thus a branch with no army and no real money winds up ordering around the branches that have the money and the guns, and that seems somewhat puzzling. All of these are easily explained if you ask a sociologist or psychologist. They're all just evidence of legitimacy. See, it's not all deterrence. My project instead offers other economic, rational choice-based explanations for why courts and other legal actors could generate compliance with law, even though it's not about deterrence. So, as I said, there are 2 things I want to talk about. One of them is law as focal point. Let me begin with an anecdote of Levy Azor's 23 years of unsanctioned service. This is a man in Port-au-Prince Haiti who is directing traffic, and he's wearing fatigues, but he's not a member of the police or of the military. Instead, I'll quote from the New York Times story from 2010 about him. In Port-au-Prince after the earthquake, driving is a 10th ring of hell. Picture roads overrun with tents, rubble, pedestrians and peddlers, tap-tap taxis, stopping suddenly, dump trucks, coughing black exhaust, 99-degree heat, few stoplights, no air conditioning, dust, beggars, and angry drivers blaring horns. Now imagine a symphony orchestra, because that is exactly how Levy Azor treats what the rest of us experience as chaos. No official entity has hired him. He is simply a freelancer with a passion for order. Azor, who works only for tips and refuses to join the police or military, has quickly become a symbol of hope, a whistleblowing reminder of the creativity that blossoms in a stateless void. So the question is, I would ask is, why did the PowerPoint just go off? Well, I don't know. Maybe someone can give me a hand, but I can go on. Why do drivers obey Azor? It's clearly not because he is threatening sanctions. It's not that he chases people down and beats them if they ignore him. Nor is it, I think it's not really legitimacy, in that if you look at the literature on legitimacy, he doesn't seem to have the characteristics that would give him legitimacy. He's not selected by a process. He selected himself. We don't know how he makes his substantive decisions, except that he probably favors people who tip better. And so those are not reasons that we would normally associate with legitimacy. Now, what you might think is, well, maybe after doing it for 23 years, he has this thing we call legitimacy, becomes an authority. But then the question is just, how did he get any legitimacy except by virtue of being effective for 23 years? But how was he ever effective before he had legitimacy? If legitimacy is something you earn by being effective, then, and you don't have sanctions or legitimacy to start out with, then it must be something else. And Thomas Schelling was somewhat prescient in his 1960 classic on the strategy of conflict when he wrote this: the bystander who jumps into an intersection and begins to direct traffic at an impromptu traffic jam is conceded the power to discriminate among cars by being able to offer a sufficient increase in efficiency to benefit even the cars most discriminated against. His directions have only the power of suggestion, but coordination requires the common acceptance of some source of suggestion. Simple coordination game, the simplest possible coordination game, illustrates, what Schelling had in mind. That you have problems that law is often concerned with, which I think of as cooperation problems, illustrated by the prisoner's dilemma, where the problem is people are selfish, and doing the individually rational thing for the selfish individual is often collectively suboptimal. In the coordination game, it's not a problem of selfishness. Even if somebody only cared about maximizing the joint utility, they wouldn't know whether to play red or blue unless something, maybe certainly without communicating with the other individual, they wouldn't know what to do. And for those of you who haven't seen a matrix like this before, I haven't typed up player 1 and player 2, but the idea is that the payoffs, the utility payoffs for player 1 are on the left of the comma, and for player 2 on the right of the comma. So both players benefit from matching at red or at blue, and both of them gain nothing from mismatching. Yet it's not obvious in one shot of the game without communicating how you would behave in this situation. This is the problem that Schelling thought revealed that there are things outside the mathematical structure of the game that affect how people behave. In other words, if the payoffs don't determine how you're going to behave, then something other than payoffs will. He called these things focal points. He said most situations provide some clue for coordinating behavior, some focal point for each person's expectation of what the other expects him to expect to be expected to do. Finding a key may depend on imagination more than on logic. It may depend on analogy, precedent, accidental arrangement, symmetry, aesthetic or geometric configuration, casuistic reasoning, and who the parties are and what they know about each other. So, for those of you who haven't encountered focal points before, suppose you were asked to name a number and to match the number named by someone else who was also trying to match the number that you named, and you can't communicate, what number would you pick? Well, there are an infinite number of numbers, so if you're just going to randomly coordinate, you're going to have a chance of coordinating near zero. When Schelling asked people this question, a plurality of them picked the number 1, 40%. So they did a whole lot better than random chance. Now you might say, is that because of something in imagination or something in logic? Maybe there's a logical reason for that. But his next example I thought was really nice, which is, what number would you pick if by matching with this other person you would win an amount of money equal to the number you named? Well, you don't want to say 1. That wouldn't be worth it, really. So at the same time, what other number would you pick? Well, a plurality of people picked the number 1 million. And this is before the era of Who Wants to Be a Millionaire. The point is, it does depend on who the parties are and what they know about each other, coming from a culture in which $1 million is somehow more salient than, $1.4 million or $800,000, then that seems like the obvious solution. Now, in the prior slide, what was the focal solution? Any students think that there was a way to play the game, or could you just guess between red and blue? Maybe if I showed this to you again, and you thought about it, you go, oh, wait a minute, it's blue. Now, maybe no one would think this, but I would guess that if I had 1,000 people play this game, that I'd probably get more than 50% of people playing blue, and they probably would match a little bit more on blue just because of the hint provided by the color in the game. So this is the idea of focal points, and my idea is that, first of all, expression can create focal points. There's a large experimental literature on this. If you let the players in the game communicate, even very briefly, like a one-word message from player 1 to player 2, player 1 sends a one-word message that says red. What do you know? Most of them will play red after that. So that is a way of making focal a particular outcome, is to express that outcome. It turns out that third parties can do the same. I've done experiments, and others have as well. It's perhaps not at all surprising if a third party or even a mechanical device points to red or blue, then that will turn out to be a simple way of solving the problem, will influence how people behave. And that, I think, explains why Levy Azor and Schelling's bystander in the intersection have the power to influence behavior even without sanctions or legitimacy. They are making salient a particular solution to this game of coordination. Now, of course, it's not the same game that I'm showing here with red and blue. And this is perhaps one of the most crucial points. I think people, when they see this, they think, oh, sure, if there's no conflict whatsoever, the law might have this effect. But the law is almost never called upon to influence behavior where there's no conflict. It's always where there is conflict. But Schelling's point was to find the focal point effect in games that had conflict as well. And that's exactly what you see at the intersection where two cars meet. They are not indifferent as to which solution they pick. Each driver wants to go first. And so they agree they don't want to meet in the intersection in a collision. That is the degree to which they want to coordinate their behavior. But they disagree as to which solution to use. each one prefers the solution where they go first and the other person waits, and yet we still see in Azor's behavior that even where there's some conflict, if there's an element of coordination, then the expression can still affect behavior, and some experimental data supports that as well. The claim then is that legal expression is one of the types of expression that can create focal points. Law can be quite salient. It's not always salient, but when it is, it can be a general purpose mechanism for creating focal points. I will say, of course, if the public is ignorant of the legal rule, it will fail to supply a focal point. It won't make salient a particular solution if people don't know what the law says. But that is also a problem with deterrence and legitimacy theory. If people don't know what the law says, they can't be deterred from violating the law, and they can't defer to the law if they don't know its content. So a lot of my effort then is to apply this to various circumstances to try to argue by example that this is a common and pervasive feature of law. Traffic rules are the obvious starting point. Part of me thinks, wow, this is way too mundane to talk about, but then, a million people die a year in automobile accidents. So even though it's not a subject in some ways for law school, it is quite important. And I think that drivers, are influenced by traffic signs. Drivers tend to know the law both because they have to be licensed to drive and because there are signs that remind them of the law. So we might think that this is a good case for the focal point effect of law. And we might think then that the traffic light, the yield sign, the stop sign, the one-way sign all have some effect, which is just to try to stop someone from having an accident. I mean, that has some effect beyond sanctions in legitimacy. Indeed, coordination in some cases may explain much of the compliance that we observe. I've read about stop sign compliance, and it turns out that stop signs. I mean, if you put aside the technical thing about people sometimes rolling through stop signs, stop sign compliance is pretty good. There's one place where traffic engineers say stop sign compliance is terrible, and they advise against using stop signs. It's at a T intersection. It's fine to put a stop sign on the terminating road. People are probably going to stop there anyway. But a lot of times neighborhoods want to slow down traffic in their residential neighborhood, so they encourage the government to create a three-way stop and put stop signs on the other two corners on the non-terminating road. Those stop signs produce have very bad compliance. And hard to explain that with sanctions. The sanctions seem to be the same in all three cases, in all these cases. Hard to explain it with legitimacy. But it is the case that you have much less reason to fear a traffic accident if you are on the non-terminating road and you don't have a road crossing you, you have a road coming to an end. That person needs to slow down just to make a turn. If they're going to slow down, the focal solution is for them to stop. If they're going to stop, you really don't need to stop. So we take away part of the coordination reason for your compliance, and we observe that compliance is a lot lower. Now, my argument at this point is to try to say that many disputes in the world can have the same structure as a traffic problem. The structure that I am talking about informally is really two things. One is that the worst outcome for each party occurs where neither of them backs down. So in a sense, there are no legal sanctions to ignoring the stop sign, but the crash that might occur in the intersection is a kind of sanction. It's just not a governmental sanction. It's built into the structure of the situation. And that is to say that it is mutually regarded as the worst outcome when neither party backs down. And the second element that's necessary here is that neither party can, with certainty, force the other to back down by making the first move. Now, there are cases where that happens. I mean, in traffic, if you're at a stoplight and you want to turn left, you pull into the intersection while there's oncoming traffic. And then when the light turns red, the people on the other road you've moved before they can move, and so they will just wait for you to move. You can, with reasonable, something approaching certainty, force them to back down by making the first move. But in general, as you approach an intersection, this is a very dangerous thing to do. You could say, oh, well, maybe I can make the first move by just speeding up and just going, 100 miles an hour through the intersection, but that carries costs. So it's not the case that you can, with certainty, force the other to back down. The other person might be speeding up too. Now, many ordinary disputes have this structure, so I claim. One example is smoking regulation. I'm talking about the simple dispute between a smoker and a non-smoker in a public place where they both want to spend time in that place, and one of them wants to smoke and the other one wants to not be exposed to cigarette smoke. They can defer or they can insist. Now, in order to make this argument work, I have to imagine that if neither of them backs down, something bad happens. Not a crash in the middle of the intersection, but one possibility is just a scene that they find humiliating and embarrassing. A shouting match, it raises their blood pressure, it ruins their mood, it makes them look bad in the eyes of other people who are around. So this wouldn't have to be the case that everyone regards this shouting match as the worst possible outcome, but if many people do, then for them this has the structure like the traffic problem, or at least the first element of it. The other is that the smoker can't with certainty force the non-smoker to back down by lighting up. Nor can the non-smoker with certainty force the smoker to back down. You might think lighting up would be the end, but it's not, obviously. The person who is exposed to the smoke might think of the harm from smoke as being linear, and so they're not going to stop arguing just because the smoker has started. They might actually escalate, and that's the whole point, is that you might provoke the very outcome that you're seeking to avoid. So if it has this structure, then the no smoking sign works like the stop sign, creating expectations that the favored party will insist, just like Azor Levy creates the expectation that the party he waves on will drive on. The stop sign creates his expectation that the non-smoker will insist when the sign says no smoking, and the best response to that for the smoker is to back down, given that the worst outcome occurs when neither of them back down. A third possibility, rich with examples, but I'll be somewhat brief, is property disputes. And here I might imagine that instead of a car accident, we'll just use violence as the possibility that occurs if neither side backs down. There's a large scholarly literature on the fact that violence is often a self-help remedy to enforce informal norms, or it's a person's reaction to being dishonored. And of course, media stories about shootings for things like breaking in line or talking in the movie theater. So even though it is a very low-level risk when we talk about these kind of disputes, it's not zero. So it's the worst possible outcome for property disputes if the amount at stake is not, enormously large. So property disputes may have this structure if the cost of fighting or the expected cost of fighting is greater than any expected benefits, and neither can with certainty end the risk of violence by moving first. Yeah, you can walk up behind the person before the dispute really exists and shoot them in the back of the head. That will work, but for the most part, the problem is that each side is trying to manifest its willingness to insist on its claim, while to the other one, which is kind of giving them notice of the conflict and removing the opportunity for either side to kind of to move first and end the dispute. Now let me digress slightly here and away from human beings and talk about the Blockhead fish experiment, which I did not do, but I think it's interesting for people who study property. It's the Blockhead fish I think is not a particularly smart fish. And so these biologists a few years ago did this experiment, and they put these male-female pair of blockhead fish, two pair, into an aquarium at separate ends. They began by putting an opaque barrier in the middle of the aquarium so that the fish each had half of the aquarium and they couldn't see each other, and the pairs would then, develop some territorial attachment to their side as well as the little cave structure in the aquarium. And the experiment consisted of removing the opaque barrier and watching what happened. And in one half of the, condition was the no landmark condition. They just removed the barrier. The bottom was this sort of, gravel that didn't, have any markings on it. And what they found was a whole lot of fighting. And after an hour or so, in 14 of the 15 cases, one pair of fish had driven the other pair of fish to the surface, which is complete surrender because they're bottom feeders. So what happened in the other condition, the landmark condition, when they left, when they removed the opaque barrier, there was a little line of rocks at the bottom, which kind of where the bottom of the opaque barrier had been. They didn't go up above the gravel, so there wasn't a wall. It was strategically irrelevant, but symbolically it just was a landmark that divided the aquarium in half. And the answer was that none of the 15 pairs were driven to the surface in that condition, that in 92% of the time they stayed on their own side of the aquarium with very little fighting. So as the authors say, that this confirms field observations that even blockheads respond to symbolic boundaries. This confirms field observations that territorial individuals, many of these are birds, set their boundaries at conspicuous features of the landscape. So, if animals without a lot of reasoning ability or are able to have their behavior be so dramatically influenced by symbolic, strategically irrelevant features of the environment, then I think it captures what I'm imagining here that law can do, that legal boundaries have some of the same influence. Obviously, in property, the ad solem rule incorporates this idea. That's sort of what the blockheads were following. This is my part of the aquarium, and it's sort of like our rule that if you own some land, you own the space above and below the land as defined by the borders. And we might imagine the law, is in this case using something that is already focal in a way and is influential on behavior in part because it's exploiting the focal point, and then to the extent that it extends this rule to more complicated disputes, it's still able to influence people by offering a focal way of who should insist when there's a dispute about property. Now, humans also use conceptual rather than physical boundaries, so the exceptions to the ad solem rule from nuisance and zoning may be able to influence behavior if they're sufficiently salient to people so that they know who is waived on and who is told by the law to concede. Then they could then that property rule could have a focal point effect as well. Treaties may not need third-party enforcement if the treaty creates what is a mutually focal point. That may be the purpose, most obviously for standard-setting treaties. If you might imagine a certain amount of cooperation emerges without any kind of law, any kind of treaty, but at some point things become like air traffic control, things are quite complex. You write down what the method for coordinating is. What you write down then it becomes the focal point, and you expect the other person to do what you've agreed to, even though there's no external enforcement, because air traffic control, you're trying to avoid the worst possible outcome, which is miscoordination. There are there'd be a lot to say about what I'm calling cooperation treaties, but again, you might imagine there's an iterated prisoner's dilemma between nations that which to some degree they're able to solve. That would be things like, giving appropriate treatment to each other's diplomats or prisoners of war, fairly easy to achieve because, you each have hostages from the other, so, I can retaliate against your mistreatment of my diplomats by mistreating the diplomats that you have sent to my country. But there could be ambiguities at some point about precisely what these diplomats are entitled to. What does diplomatic immunity entitle them to? What are the conditions when they can be expelled and treated by process of law and so forth? So, in other words, there's a need to coordinate on the precise meaning of cooperation, and we do that. We write it down in treaties, and then those treaties are the focal point solution to our long-term cooperation problem. Another, I guess, along the same lines, the law will sometimes codify custom, and by codifying it, it can cause people to behave slightly differently. People are already obeying a custom, but run into some ambiguity. For example, suppose you wonder if the flag is soiled and I want to dispose of it. Should I bury it or should I burn it? Well, this is a perfect kind of coordination problem. You want to do the thing which others regard as showing respect, and you might make a mistake here, and depending on regional variation or change in the maybe the flag burning of a certain time period by people who are protesting the United States suddenly changes the meaning of burning the flag in order to show it respect. So there's this strange statute for U.S. Code sections 5 through 9, which describes itself as a codification of existing rules and customs pertaining to the display and use of the flag, and just sets out what one should do in order to show this kind of honor, and then it's self-fulfilling. One then shows honor by following what this rule is, which is what most other people will do, and how they will interpret what you do. A more important example, maybe the Lieber Code from 1863, was the first comprehensive codification of the rules of warfare. And there are lots of things to say about it. I just picked out one example, which I thought was kind of interesting if you're thinking about the coordination function of law, that the Lieber Code, it has actually just, first of all, it just descriptively says it is customary to do the following thing. And you might wonder, why is it saying that? Well, because it's useful information to shape behavior if people are trying to coordinate and you're telling them this is how lots of people coordinate. It's customary at the time to designate by certain flags, usually yellow, the hospitals and places which are shelled, so that the besieging enemy may avoid firing on them. So whether or not the countries want to refrain from shelling the other side's hospitals is not a function of the law in this account. It just can emerge as a form of cooperation in an iterated prisoner's dilemma. But then again, you have this issue of how do we coordinate on the method of cooperation. If we make mistakes and we shell each other's hospitals, we need to know whether it's plausible that it was an accident or not, and it helps to have some precise way of signaling that. Social movements are able to benefit from law in a way that exploits the focal point power. Again, imagine that smokers and non-smokers are seeking to coordinate on where to insist on their getting their way without causing a scene. But imagine that non-smokers in 1990 become very unhappy with the fact that there are lots and lots of places where the norm is to defer to smokers. They would like to change the norm. How do they do that? Well, collectively, they could do that if they could produce a lot of confrontations with the smokers that produce a lot of these outcomes that are quite undesirable. They're shouting matches or such. But if you were to sacrifice for a time to do that, then eventually the smokers would back down. But if that's the case, coordinated confrontations would be more powerful than uncoordinated confrontations. I can think of at least two reasons why. There might be strength in numbers. There might be situations where if you're one of many non-smokers, you find it easier to engage in the confrontation than if you're the only one. And pick your battle. It might mean that you're willing to do your share, but you're not really a complete fanatic, and so you really don't want to have more than, say, one of these ugly shouting matches a month or a week. You have to pick your battle. And so if given these issues, there could be some advantage to coordinating. One solution is that law identifies particular locations of non-smoking. In the early stages of these laws, they would often just require restaurants to have a non-smoking section. The advantage of a non-smoking section is that it allows non-smokers to coordinate by sitting there. That is, the smokers may be indifferent at first where they sit. The non-smokers flock to the non-smoking section. The non-smoking section now provides some strength in numbers, and they're more likely to confront the smokers who try to smoke there. If the law says no smoking in public buses, then or bus depots, then the person who's going to pick their battle now knows, okay, I'm going to be a jerk about this once a month, but I'm only going to be a jerk about it in buses or bus depots. And then if there's a concentrated effort by non-smokers in this way, then they may change the norm in that area. The law then offers them a way of coordinating their resistance. Now, admittedly, I am more than halfway through. But I did put this in here to say, it's time to wake up. If you gave up on the focal point theory a little while ago, I've got another theory for you now. And it's actually a very simple one in a way. I think the first one is if you haven't really studied coordination games, is a bit more complicated. This one just says that there might be informational content to law, and people might then observe the law, update their beliefs in light of the information that law provides, and the new beliefs might create incentives to behave differently. I would like to point out that deterrence is an information theory. When we say, why is it that the imposition of sanctions on A at time 1 will deter wrongful conduct by B at time 2? What is the reason? Why does B care about what happened at time 1 to a different person? The potential wrongdoer is supposed to infer that the enforcement actions at time 1 predict enforcement actions of time 2. Maybe they tell us something, maybe the enforcers are the same at time 1 and time 2, and this is revealing something about their motivations, their budget, their capacity. So my idea is simply that law might reveal information besides, or law enforcement might reveal information other than deterrence. So what else might it reveal? Well, one possibility is that it signals attitudes, public attitudes, that if legislation tends to be correlated with public attitudes, then it is evidence of those attitudes. The smoking ban might reveal beliefs, the legislator beliefs about public disapproval of public smoking, especially if you think about, a municipality in 1985 passing a ban on smoking. For many smokers who have been smoking for decades and used to complete deference to it, it must have been a rather dramatic wake-up call of information that it was easy to sort of ignore before the law any changes that were going on, to think that someone was just being a jerk if they objected to your smoking because you'd grown up in a society that found that okay. But the law being enacted tells you that the legislators must think that there's more popular disapproval of smoking than you had thought. Now, this is based in part on legislators having expertise in public opinion. It might only apply to certain subsets of law. I mean, there are plenty of areas of law where we don't think that the public, the popular thing is being done through the law, but those tend to be mostly low salience. That is, it's easier for minorities to capture the legislature and get what they want if it's a low salience thing like a tax, a bill rider or something like that. Those are unlikely candidates for any kind of informational effect anyway. The only kind of legislation that would have an informational effect would tend to be that which is covered by the media. If it's high salience, then it tends to be something where the legislators are more afraid of bucking public opinion, so the law might then be well correlated with it. And this seems particularly true when the law is opposed by some concentrated industrial interest. Like in the early days of smoking bans, the tobacco industry tried to stop them. And so when the tobacco industry was defeated, then that was particularly strong evidence that the public was in favor of these laws. Why might that affect behavior? People might care about disapproval both for instrumental reasons and because they value approval or esteem intrinsically. So they're updating their beliefs about this might change their behavior. I'll just mention this one example. Funk, 2007, she studies the repeal of some symbolic laws mandating voting in certain cantons in Switzerland. And I say symbolic, there was a fine, but the fine was something that had been set many, many years ago, and it was 1 Swiss franc, and it was so low that it seemed fairly obvious that the cost of voting was higher than the fine for not voting. Yet the repeal of these laws decreased voting, and so the attitudinal theory would be that it signaled people that there was less disapproval of shirking on voting than there had been at one time in the past, less concern that this is something that your neighbors will think is your obligation to do. What else might the law reveal? It might reveal information about the risks and benefits of regulated behavior. A smoking ban could reveal beliefs about harm. The argument here is not that legislators are experts, have any expertise in the scientific evidence, but rather it's simply that they aggregate their information on harm by voting so that the voting of a large group contains more information than the individual observing this would otherwise have. And in a model that I wrote with Dhammika Dharmapala here, we examine legislators voting strategically and find for various reasons that strategic no votes are more likely than strategic yes votes. So if the law still passes, then it really is evidence that the individual legislatures were believe that the behavior they're banning is harmful. I want to mention spillover effects and or expressive externalities, because I said at the beginning this isn't all about compliance with the law. I think I'll just use this drug legalization example. I think there's a lot to be said for decriminalizing drugs. One of the unintended consequences might be that you would send some signal of both attitudes and harms, that you'd be signaling that these drug use is way more popular now, there's much less disapproval, and on the other hand that the people who've thought about this don't really think that it's that harmful. Those might be signals you'd like to not send at the same time that you're ramping down the criminal prohibition of the drug war. I mean, of certain illegal drugs. In Portugal, I interpret what they did a few years ago, where they made a strong move towards decriminalization. At the same time, they created this complicated committee that, if you are found in possession of a certain user amount, you get a ticket. You're not going to go to jail, but you also get told that you have to report to like this local committee that has like a psychiatrist on it and a social worker on it. And as far as I can tell, you can basically ignore everything that committee has to say. But I think the idea might just be to kind of, make it seem like send a counter message. At the same time we're decreasing the criminal sanction, we're trying to also send the signal that no, there's something seriously dangerous and wrong about using these drugs. So that's I think, attention to potential spillover effects. I have here the stand your ground law, which I think is the controversy about this law. I think I'll just say this without explanation. I think it makes no sense if you just focus on the substance of the law, that it had nothing to do with the Trayvon Martin, George Zimmerman case. I do think, though, that this law sends a surprisingly strong message that there's public approval of using deadly force in cases where it's not really necessary, in cases where it's sort of borderline at best, and that might actually produce more questionable killings, even though it didn't have anything to do with that particular case. I think that may be why people focused on it to the extent they did. Well, legal compliance is never perfect, and I try to spend some significant time talking about the limits of all of these effects. Obviously, the focal point effect requires a particular structure of a situation that many people who in the legal literature are extremely fond of making claims about the law sending a message, a good message, a bad message, it strengthening stereotypes or something, without any effort to kind of explain what their theory of expressive effects is. And clearly the focal point theory has a variety of conditions, this information theory. I'll just give an example of what I think is a bad use of this kind of argument. I'm not a fan of gender-based peremptory challenges, but there's this longer quotation in this case where they make it seem that gender-based peremptory challenges are going to have some effect on the way that people think about men or women. And I find that, like, I guess anything's possible, but it does not bother to stop and say that, most people don't know what peremptory challenges are. Most people who are sitting in a courtroom don't know when a person is being struck for a peremptory challenge versus for cause. If they know it's a peremptory, they don't know why. The only way they might think they knew was why is if the jury was all male or all female. And yet this rule doesn't stop us from having all male or all female juries. We do. And so, this rule wouldn't stop that, but it does stop a person from striking a single individual because they were of a certain characteristics, one of which was a certain gender, and I don't think that's really sending any message that anyone is actually going to hear. So I conclude. So I didn't spend much time talking about the limits. I really do in the book, because I do kind of chastise various courts and some academics for just relying too easily making these kind of expressive arguments. And my hope is that by developing the theory, we can limit claims to when it's more plausible. But in conclusion, any economic model of law, I think, should routinely consider how law influences behavior in ways other than the threat of sanctions. That is all. Amreen?
So to continue on your last sentence of recognizing the limits, can we go back for a moment to the fish example? What kind of fish was it?
The blockhead.
Blockhead. So, it struck me, the reason I want to go back to that, because it strikes me as the kind, well, I believe that that's what happened in the experiment. It takes an awful lot of experiments with many kinds of fish and creatures to get this result. It's distinct because you got this, and good fish, eliminate the barrier and they'll start fighting, and maybe even the blockheads, after an hour of recognizing the expressive effect of the boundary, eventually, battled over the terrain. And so it really raises the question I want to ask is, how common, how often are these things, do these things happen to be taken completely seriously? If you had to run 1,000 experiments to get one example, hypothetically, would that tell you that there is no expressive effect, or how do you figure out the importance of the theory? I'm not saying this to doubt the importance of the theoretical breakthrough that your account develops. I think it's fascinating, but I'm trying to figure out how much we want to get.
I mean, I would say two things. Just for the fish, I mean, I thought it was an interesting result, and I maybe should have talked about one of my experiments on human beings, which I actually took out because it was. I thought this was a sort of remarkable result. Now I don't know. Now, when you say, is it just 1 out of 1,000 that they try? I mean, my understanding from reading some of this literature, as I had up here, the observation of animals in the wild often shows this sort of thing, that they seem to be attentive to these landmarks which are payoff irrelevant, and that seems surprising. It would seem like they would not pay attention to that, but in fact weaker animals sometimes, or smaller animals, which are usually a good proxy for being weaker, more likely to lose the fight, will sometimes fight when they are sort of defending territory which has been defined by some landmark, even though they won't fight when they're the aggressor. And so there seems to be something real about this. I guess I think humans are much more capable of being sensitive to this stuff. So for me, the idea that some animals could be as well really emphasizes its importance. Now, the other question, the main question you're asking, is really about magnitude, and this is partly why I wrote a book, because I thought when it comes to focal point effect, there's nothing I can do other than to try to examine, example after example, and see if I can make a convincing argument that there's some effect on behavior that's going on that is not explained by sanctions and that is not explained by legitimacy. Ginsburg and I did this study of the International Court of Justice, and we found a remarkably high level of compliance with its decisions. But we looked at those decisions, and we found that a lot of them are about, in a qualitative sense, I could characterize them as fitting this idea. That is, a lot of them are about, you look at the stakes and you think, well, that wasn't worth fighting a war over. This wasn't like, your country would live or die on this dispute. It's like the Falkland Islands or something. It was kind of dumb to go to war over. And so it's not a surprise that these are the kind of cases that get taken to this arbitrator that has no real sanctioned power. And then if people are willing to go to that arbitrator, it's not a surprise that they would just go along with it. So it's really an accumulation of examples like that. And I guess what I said at the end of the very last slide is I would hope that I might encourage people to think of ways of if they were thinking about these ideas, then they might do a better job than I have of thinking about how to test them and measure the quantity. Lee.
So I have two kind of linked questions, or maybe it's a two-part question. Only part of it is about the fish. I was wondering whether your focal point theory ends up really drawing on some kind of legitimacy account to some extent, and I wondered that in sort of two respects. One is brought to mind by the fish. It seemed from the experimental design that when they took away the barrier, probably that line of gravel was like put right where the barrier was, and probably the two halves were even. But I'm curious about what if it were really uneven and the one set of fish discovered that the other fish having this enormous territory, would that somehow change the results? And related, somewhat related point is having to do with the yellow flags you mentioned for the hospital.
Right.
Which is, to what extent do we need the law to kind of certify that focal points are valid? Because we might imagine kind of a cheap talk story where people would put the yellow flags everywhere to avoid, or at the most strategic places they didn't want bombed. And to what extent do we need some kind of governmental legitimacy backing up the focal point?
So, I mean, it would be interesting. I mean, it would be interesting to rerun the experiment in the way you've just described of the blockhead fish. My understanding of animal studies is that there are a few animals that are sensitive to this sort of thing. I don't think blockhead fish would be, but even if they were, I don't have anything. It's not my goal to kind of destroy legitimacy theory. It's just my goal to say that's not all that is going on. And just because you see something without sanctions working doesn't mean it's working because of legitimacy. The field studies that I've read that talk about birds, they make the point that you'll have these like flocks of different species that are somewhat antagonistic toward another, and they'll land and they'll create territory in a sense. It's sort of temporary, but it's based on landmarks. And then what happens is the population is constantly changing. So other birds are taking off and others are landing. They're landing with birds of their sort. And what happens is that if you were just measuring the power dynamics, then they would be changing a lot, and maybe the fairness and unfairness would occur, because it's like, oh, now these birds over here started out with an equal amount of space, but now there are twice as many birds as over here, and they have but there's a huge amount of stickiness to it, is what they observe. And so and the stickiness is based on, there's this rock, and we stay on this side of the rock and you stay on that side of the rock. So anyway, with human beings, it is, this is the argument that people will make about, Azor Levy, that he is being fair in the way that he allocates the right of way, and so people are respecting the fairness. But nobody has any idea. It could easily be, he's being tipped. I mean, why wouldn't he be, letting the good tippers go on? So is that fair? Maybe it is. I doubt that people who are bad tippers think it's fair, but they do think that they're going to crash if they ignore what he says. Yes?
If the parties were able to negotiate beforehand, say with maybe the help of a mediator, and were able to bargain with their dollars, wouldn't they arrive at the same conclusions? The same solution if they're able to bargain beforehand? But in many cases, like at the intersection, they can't. So really, the law is just a proxy for what people would arrive at if they were free to bargain.
Well, it's definitely
it's so analysis.
Yeah. So another way to put that is that, look, in a lot of these games, it would pay for each side to agree to just flip a coin. Let's just flip a coin. And, heads, you get to go first, tails, I get to go first. But you're right, the transaction costs for the drivers are too high, right? They don't want to stop, get out of their car, agree to flip a coin, get back in their car. It's faster not to do that, so the third party creates this benefit. Now, what Schelling said was that it's that and I didn't really say much about this, but there's this benefit that Azor Levy is giving to these drivers, because if they all obey him, he's removing the possibility of they're both waiting or they're both proceeding and crashing. And those subtracting those bad outcomes creates a big efficiency gain to them. Now, the way he put it was interesting, because he says the most discriminated against car still benefits. And so at least, I agree with him, that it doesn't really matter if there was a fairer way to do it. You could still be benefiting from the fact that this person is offering you a means of coordinating that is better than having no means of coordinating.
More efficient, basically.
It could be.
Isn't that just very efficient now?
Yeah. I mean, it could be. So you can measure, like, you can measure, like, what people expect to get out of the situation if they have no coordination device, and they're sort of mixing strategies. And then that, presumably, all that the mediator has to do is to beat that, and then you would go along with it. It could be that a mediator would be so biased against you that you would actually be better off without any mediator at all, and then there'd be a reason to try to resist putting yourself in a position where that mediator could create a focal point that would be to your detriment. But yeah, traffic lights are the ultimate randomizing device, which we're all better off than by just, in general, by following. Yes?
So I'm kind of having trouble differentiating between the kind of, I guess, the benefit of signaling, in that if we coordinate, there's a benefit, that's why we coordinate, as opposed to the deterrence model of, if you don't coordinate, you're penalized. Because in the coordination, you're basically you're penalized in the sense that you're giving up the opportunity cost of coordinating. So isn't it effectively the same thing?
Well, it's not the same thing. I don't necessarily resist the language you want to use. As I said at one point, there is a kind of sanction for having a coordination disaster of, like, crashing in the middle of the intersection. It's just not what we mean by deterrence, which is the government imposes cost on you. It makes you pay money, it puts you in jail. And this is in the structure of the situation that you're not the only one who suffers, by the way, if you crash, the other person does too, but the risk of that may be enough for you to give power to the person who is offering a means of coordination. So, I mean, it's simply to say, if this is a police officer in the middle of the intersection, in addition to the possibility that you will crash, you also have the possibility that you will get a ticket and the government will make you pay. So those are the things that I mean to separate. So.
I guess I want to push back a little bit on the Pareto claim and why you agreed to it so fast.
Okay.
And maybe I'm misremembering the Port-au-Prince story a little bit, but bear with me a little bit. So in the absence of the guy, we would have, sort of spontaneous law, most likely, where people would alternate at an intersection. I mean, we find that very often coming out of driveways or traffic jams or whatever. And I mean, we could call that law and focal point as well. I mean, it seems it's an easy one. Now, it's not necessarily efficient, right? There might be, 100 cars on one side and 6 on the other. It might be that people are more in need of one side than the other. I mean, it might be that they wouldn't agree to it. It might be that it's really inefficient, that people trying to go down the road see the people alternating 1-1, and they go into the Treasure Island parking lot just in order to come out of the driveway in order to do the 1-1, a kind of common piece of behavior. So, we understand the focal point of the spontaneous law. Just that usually law or some intervention has a better way to do it. Can overcome or provide either more efficiency or more something. So the traffic light, for example. Now the guy, I think, is really a bad example because it's telling that he puts on the camouflage uniform. I mean, it would be more fun if he looked like a jerk and unofficial, and we would test it by seeing, well, what if he did something that we're sure people would see as either unfair or something else. I mean, it would show that Schelling was wrong, I think. I mean, say he only let yellow cars through, or only let men through, not women, or, he seemed to let one side come through for 30 seconds, then he blew a whistle and stopped them, and then he gave the other side 8 minutes, to come. I really doubt that, I think we would have more than chaos. People would get out of the car and object and scream and all that. I mean, we would have some trouble explaining what law was there. It's not even second best. I mean, I sort of feel like that's where the action is. We have to wonder where law competes with the spontaneous law.
Well, I'm not really defending spontaneous law as being better than law, even though that quote from the New York Times is this kind of romantic, like, stateless void, creativity, so forth. So I'm not saying that he is the best way to solve that problem. I'm also not saying that it wouldn't matter what he did, people would obey him. I agree with you that at some point, if he just held up, one line of traffic for half an hour, at some point people would just say, "That's it, I'm going." But I do want to just distinguish two reasons people might disobey him. One is the shelling reason is that you might actually, be operating in a way you're making the person worse off than they were when you weren't there and they were going to mix strategies in some way. The other possibility that Lee is saying is, well, no, maybe as soon as you introduce the slightest ingredient of unfairness, that they were still better off, they would just be so resentful of this person for being manifestly unfair. And maybe that's true. I mean, if legitimacy matters, then maybe that's true. I don't know. What I really just want to extract from the situation is that there's an influence on behavior that is not sanctions and not legitimacy, but not that that spontaneous order will figure out the best way. And I agree with you. If he's not there, something else will happen. I mean, Schelling's example is there's a traffic light that's broken. So he's imagining a single spontaneous person going to the middle, not a kind of long-run solution. The signal is the long-run solution, but the point is you obey the signal because it does, let you alternate in a way that makes everyone better off. But I mean, here's where I would say, Schelling does give this example that I kind of agree with. The line down the middle of the road. He says you could probably err substantially. Like, I wouldn't think, even if you introduce some sort of, ethnic group differences that, disproportionate effect, I wouldn't think that the fact that the line wasn't exactly halfway through the middle of the road would really have much of an effect on people's compliance with it. They would. It's a quick visual cue for how to coordinate your driving with the other drivers on the road so you don't sideswipe each other. And it would have to become extremely unfair, I think, before you would just decide to ignore it. Yes?
I was wondering if you could help me understand the distinction between the informational function, your second kind of subcategory of expressive theory, from legitimacy, because it seems to me that the informational signal depends on a belief in accuracy. So perhaps I follow the law and take only the FDA-approved drug because I think that they must know what they're doing, and there's a reason that that's been approved, and so that's a signal to me that it's safe. That's the information I'm getting from that law, so I follow it. But that seems to me that that's similar to a claim of legitimacy, that I'm assuming that the laws are correct, that they're accurate, and that they're leading me toward safety because I think the process that led to them involved expertise and consultation, or, to use your examples, it involved some kind of democratic process which aggregated opinions, so it is an accurate signal of what many people believe, which again is, at least in our system, a legitimacy signal that many votes were calculated and many voices were heard.
Let me just describe legitimacy slightly more, because there are people like Tom Tyler who say that what affects compliance is people's perception of procedural legitimacy of the law, which he operationalizes by looking at how what people think of the courts and the police and how their interactions with courts and the police go for them and their family and friends. And so the idea is that if the police and courts treat you with respect, then whatever the rules are, you'll be more likely to obey the rules because you feel respected by these parts of government. The substantive legitimacy, someone like Paul Robinson says that the more that criminal law corresponds to your moral intuitions, the more likely you'll comply with criminal law in those cases where it doesn't comply. So if if 85% of the time you think the criminal law gets it right, then maybe the other 15% of the time you'll defer to the criminal law. And I guess maybe it would be relevant to some. I mean, I could see some overlap in this, but it seems distinct. First of all, the harmfulness thing seems distinct. I mean, that's not really. We're talking about whether or not. I have some belief about my exposure to secondhand smoke and how much it's harmful, and that affects how much I will try to avoid secondhand smoke. And that might include asking people to stop smoking around me. And so the law, if it increases, if it changes my views of the harms of secondhand smoke to make me think it's more harmful, then it turns out I wind up enforcing the law because I tell smokers to stop smoking in all situations, including the ones where they're forbidden by the law from smoking. I don't think that's either the procedural legitimacy, because I think courts or police treat me well, nor is it kind of the substantive that I care about, the way that if the law normally gets the moral point right. It's just I care about myself. I have a belief about how harmful this is to me, and the more harmful it is, the more I'll do to stop it. Now, the attitudes, maybe that's connected, but I guess, for example, one of the things I claim is an implication of the attitudinal model that I described is that local laws are likely to have a stronger expressive effect of this sort than national laws. And that's because the attitudes that you care about are the people who are going to notice your behavior and to approve or disapprove of it. Now, the internet complicates this, but certainly for a long time, those would have been people who, your neighbors, the other members of your local community. So I'm not sure it's the same. A legitimacy theorist, might care more about the national consensus, right? Because that might be closer to the truth or something. But I'm just imagining, you just care what the people, when you walk your dog, what the people think of you if you don't clean up after your dog. You only care about the people around when around you and your dog. So that seems like a different inquiry than legitimacy.
The dog example, one of my favorites, because that has a strong economic implication as well, which is at night people are much less willing to pick up after their dog because nobody's around to look at them.
Yeah.
The other question I was going to ask you is you use the...
And I discovered that snow creates that problem this winter. I discovered that as well. When the snow melted.
But part of it is there are fewer people out walking.
Right.
Snow and cold. And I'm an expert since I have 2 dogs. And I also lived in Hyde Park during the period where you could not walk in any of the parks or any of where there was grass. You could not walk without stepping in something, and that's certainly not true anymore. What did you? The first slide, the second slide, you had the gold mining example.
Right.
In the gold
rush.
1850, the gold rush in 1850. Right. Now, were you using that as an example where there were no sanctions?
That's a complicated example. I mean, there's not really government sanctions, but yeah, there is cooperation amongst the miners.
There's a very good paper published in the Journal of Appropriate when Coase was still the editor.
Yeah.
It was called, I think, Order Without Law.
Yeah.
And what it did do was there were severe sanctions. The sanctions, however, involved being expelled from the camp.
Right.
Right. He also, the person who wrote it also went through all of the records and found very little use of violence, that people just, if they did cheat, they were simply expelled from the camp. So there were severe sanctions, it just was not a formal law.
Right, and I mean, I talk a lot about informal sanctions, informal customs, and the idea that, in a way, the question is, what does centralized statement of the law add to what's going on? And so I'm completely conceding that there's a certain amount of cooperation, a certain amount of sanctioning that is occurring without government as a bottom-up sort of decentralized order without law. All I'm saying is that there comes a time when things get complicated. There are ambiguities about what the rule is. There's the borderline cases. There's a question of does this new set of facts result in a new outcome? And that's where it becomes useful to write down what the rule is, and to try to write it down in a clear way, and that can then become a focal point that kind of supplements the order that already exists. The analogy I have is to a dictionary, that language is informal order. It can be very regularized before anyone writes it down, but when people write a dictionary, we think that tends to have some influence on the way that people use the language afterwards, even if it's purely descriptive, because people have a desire to coordinate on the spelling and the usage of words so that they'll be understood. So I didn't mean to suggest that there was. I just meant to say there was no government sanctions in those cases.
Time for one more question.
Yes.
So I like that you have the conclusion slide up, and I want to ask two questions that arise from that. So that's your recommendation, but in order to really want to act on that, what I'd like to know is, in terms of if you compare the sanction effect of law or the sanction efficacy of law to the information efficacy of law, how do those compare? That is to say, how much, if we compare the impact that a sanction can have on behavior, how much does the information impact of law have on human behavior in terms of orders of magnitude? Is it roughly comparable, or if it's possible that the information impact is second order or third order, then maybe I don't want to insert in an economic model. I want to stick with the old ways. The second thing I wonder about is, one of the nice things about the sanction models of law is that it's really easy to come up with prescriptions about policy. The problem with information models about law is that you have to specify a ton more, people's information sets, the games they're playing, things like that, in order to come up with clean prescriptions about what the law ought to do going forward in a particular context. And so that makes me wonder, maybe there's an influence, but it's too complicated to really engage in normative policymaking or normative suggestions about what the law ought to be doing in specific contexts. And so I still I should stick to the old approach.
Yeah, I mean, in the last chapter of the book, to take your second question, where I talk about policy implications, I do say that I don't, it's very difficult to imagine, trying to wield the information power. I do think that there are some normative implications, like, the point I made about drug legalization and other other examples where there might be spillover effects, things other than compliance, which might be undesirable. And then, this is telling you to, that's why I point to this Portuguese idea as a way of trying to mute the undesired informational effects of the law. More, for focal point, I think there are ways of trying to make policy, of trying to use that, and I talk a bit about that. You need to know where there is potential for a focal influence of law. It helps identify when it's important to spend money on signs, it's an argument in favor. I think in the rules standard debate, it's one more factor in favor of rules rather than standards, because it's hard to align people's expectations with a standard, much easier with a rule. That's why we see, for example, traffic rules more than we see traffic standards. So, I admit that, a lot of the purpose of this is is not policy-oriented, but really trying to understand how things operate, like international courts, what's really going on. Now, and the first point, is Omri's magnitude question, and I don't really, have. I address it in various ways, in the book to try to argue that the effects are not third-order effects; they're more important than that. But information in particular, I agree, it's highly contingent. That's one reason I'd say identify some things that I think can make for discontinuous effects. But I say in the normal case, it's probably just a marginal effect of some additional compliance that is only a few percent more than what you would otherwise get. The focal point effect, I think, I have arguments that I think there are cases in which most of the compliance you're observing is actually caused by the focal point effect in traffic, in international context, and some other context. And so I may, not persuade you, but that is at least my claim, is that there are contexts in which that effect is the main effect going on.
Thank you, Richard.
Thank you.